Thank you, Dyson, for a tour de force, which we're accustomed at these meetings to expect from you. Ian, would you come forward and speak to your friends and admirers and perhaps tell us how it was that, to continue the cricketing metaphor, you have shots around the wicket in every part of your life.
Friends in the society, it is very, very difficult for me to make a response to the enormously generous morning or sessions devoted to me. I thought on several occasions you must have been speaking about somebody else. But I nonetheless am very grateful and very appreciative. May I say something about those speakers, because to adapt what Winston Churchill said about alcohol, he'd taken more out of alcohol than alcohol had taken out of him. And I've taken a great deal more out of the people whom I've met and who've assisted me over the years than I've ever given to them. And I'm enormously grateful to my parents who struggled to send me to a good school. I'm grateful to the school for the aspiration that it taught me. I'm grateful for the many other opportunities that were afforded to me. Mention was made of the fact that I had been a junior partner in a small firm. I think that was an enormously valuable experience for me. The senior partner in that firm had won a military cross and been promoted to Lieutenant Colonel in the field in the First World War, and the other partner in the firm had been a navigator of Catalina, or a reconnaissance aircraft, flying deep into the Indian Ocean during the Second World War. So I met good people and I was encouraged and assisted by them. The first speaker today was Amanda, who was my last associate. I wouldn't like to say that she was better than the others, because the others were very good, but so was Amanda. Amanda was sympathetic, she was very smart, and I knew that she would have a good career. In fact, I owe quite a lot to all of my associates. I had 17 of them whilst I was on the court, some of them for 2 years, which was a little unusual. They were clever young people who were very sympathetic, and they remain friends of mine. In fact, I'm lucky in that regard too. I've got an enormous extended family because I'm in regular touch from time to time with all of those 17 associates. Amanda spoke about the work choice case. I've forgotten who it was. I think it was a French aphorist who said that if I'd had more time, I would have written a shorter letter. It is an interminably long judgment that I wrote there, and I wish I'd had more time to distill it. But I don't regret it. It is an avowedly federalist judgment, and I make no apologies for the sentiments or if there is a legal philosophy, the legal philosophy in it. I think I wasn't a federalist. I never thought of myself as a natural federalist. It wasn't inevitable that I would be, but I think the fact that I came from a very decentralised state made a contribution to that. Queensland is the most decentralised state. It isn't realised by a lot of people outside Queensland that right from late colonial days, there was a northern judge in Townsville, a central judge in Rockhampton, and they were all, in a sense, separate provinces, although they did go on circuits, and if you were a Brisbane barrister, you would often go on those circuits. I had a retainer for a couple of years when I was a junior from Mount Isa Mines. It was a kind of it was rather like Newcastle in Sydney. It was a very valuable retainer to have. But one had a sense of the size of Queensland and the different attitudes. Cairns is much further from Brisbane than Casino is from Brisbane. If you practiced in Queensland and you had a broad practice, you had that appreciation. I also had the advantage of later on having a practice that did take me to other states, including this one. And one does get a sense of the magnitude of the country, and although it's the same country and the same people, there are undoubtedly different approaches. As Richard Court said last night, things get lost in the sands of the Nullarbor on the way across, and that is true. So that there were factors, if I look back on it, which made me federalist in thinking. There was also this. It seemed to me that it is important that there is a diffusion of power. I think I had an apprehension when I went on the court that there was far too much centralisation of power. And one only has to look at the education system in this country. I think we rank about 17 or 18 in the OECD in educational standards. And in my opinion, the Commonwealth has no role in education at all. It should keep out of it. And every time it's touched it, it's made it harder and worse for young people. On the question of federalism, I don't think I ever thought deeply about it until one day when I was interviewing a candidate for a position as associate, a young man called Gim de Villa, who is now the Solicitor General in Queensland, a very, very able young man. And I interviewed him. I always say he interviewed me for his job. Very polite, but very persistent. And at the end of the interview, he said, "Can I ask you a question?" And I said, "Well, you've already asked me a lot, but you can ask me another one." And he said, "Are you a federalist?" And I said, "Gim, I don't know about that, but I think I'm the closest to one you're going to get around here." So that was my thinking on federalism. If I can now say something about Xavier, and I should say when I start to talk about Xavier that I'm enormously grateful for the support I got as president of this society from Stuart Wood and Xavier Christie and the other people who helped or really are the ones who are responsible for the great growth and I think increased prestige of the society. And I want to put on my record how much I owe them. But with respect to Xavier's paper, or Xavier's speech about the appointment of judges, I'll tell a short anecdote. When I retired from the court, I had a telephone call from Diana Bryant, who'd been appointed the first Chief Justice of what was a kind of an amalgam of the Federal Circuit Court and the Family Court. And Diana said, "I want you to go on a panel, to chair a panel, with respect to the appointment of judges to the Family Court." Let me immediately say this about the Family Court. I don't think the Family Court gets an entirely fair deal from the legal profession as a whole. There's a kind of a condensation or almost a kind of a condescension on the part of some lawyers towards that court. But in a society, a modern society with many, many fractured relationships and children as casualties, the family court is a very important court. And Diana said, would you be prepared to chair the panel to make recommendations to the federal government with respect to the appointment of family court judges? And I said, Diana, I don't think I'm the right person for that because I don't believe in the panels. I said, I don't think that the appointment of judges is a privilege. I think it's a constitutional obligation of the executive government, which is answerable to the public, to the parliament, if it gets it wrong. And Diana said, she was very pressing. I knew her a little. She said, look, I really want you to go on it because the federal court's got Brennan and I want a High Court judge. So I went on it. And nothing that I saw on that panel, we made a number of recommendations. Two in particular I recall. We were unanimously in favour of two outstandingly good candidates, and they didn't get appointed. The panels are used, I think, as a kind of a blind to enable the executive government to do what the executive government wants to do. And I'm on record as saying that I'm opposed to them. In fact, I did speak before I left the court at an international conference in Cape Town, and there were representatives of nearly all of the Anglosphere at this conference, and I was the only one who spoke against panels. The chairman of the English Bar was there, and he was very, very complimentary of the way in which panels had operated in England and Wales. In fact, they haven't been good. They have not been good at all. There have been many, many missteps in relation to them. But as I said before, at heart, the appointment of judges is not a privilege, it's a constitutional obligation, and the executive government needs to perform it, and it should perform it by appointing the best candidates it can. Now let me say this, that appointment to the High Court, you've got to be lucky. I think the story attributed to Napoleon is when one of his marshals was recommending the appointment to general of a particularly successful officer. He said to Napoleon, he won this battle, he won that skirmish, he did this, he did that. And Napoleon said, but is he lucky? And I was lucky, and really anybody who's appointed to the High Court is lucky in this sense that there are always many, many candidates who could have done the job very well and sometimes better than the person who's lucky enough to get the appointment. And I was certainly lucky in that regard, as I have been in many others. If I can then move to the next speaker this morning, Justice Stewart, and I was amused by Justice Edelman's introduction when he quoted something from the Rhyme of the Ancient Mariner by Coleridge, because there were times when I was on the High Court, and in particular in the work choices case, I felt like the Ancient Mariner. Alone, alone, I think this is right, alone, alone, on a wide and windless sea, and never a saint in sight to save my soul in agony. And that's how I was on the court, and in particular in the work choices case. There was much in Justice Stewart's paper, which was enlightening and informative, as one would expect. However, it did provoke in me a thought of the obverse of the coin, that the courts, it is said, should not interfere. The courts should be separate from Parliament and the executive, an idea with which I entirely agree, and that the courts should not be exercising any kind of a quasi-legislative function. But people rarely look at the other side of the coin, where the legislature comes close to, and in my view, exercises what is really a judicial function. And there's a very good instance of that, I think, in this state. Mineralogy, which is Mr. Clive Palmer's main investment vehicle, won 2 arbitrations against the Western Australian government here. They were very long arbitrations, a great deal of money involved, and the arbitrator was highly respected Michael McHugh, former judge of the High Court. Those two, the effect of the 2 awards that were made by him was that he did have a case against the Western Australian government, and there should be a 3rd arbitration for the assessment of that amount. Now, Mr. Palmer's not a man to understate things. Mr. Palmer said his claim, I think, was worth $30 billion. In any event, and I think this is rather shameless, frankly, both houses of Parliament here unanimously cancelled the 2 awards. Now, the matter went to the High Court, and one of the arguments presented on behalf of mineralogy was that in doing that, the Parliament had acted, had exercised a form of judicial power. Now, I'm not saying the argument's necessarily correct, but I am saying this, that I think it has some legs. I think it could certainly be argued, because awards, commercial awards, can be registered and enforceable as judgments throughout the Commonwealth. They're in reliance of the full faith and credit section of the Constitution. Any award can have the effect of a judgment, and indeed it can have international operation under various international instruments. So that to cancel 2 awards, I thought was arguably, potentially, an exercise of judicial power by the Commonwealth, by the state of Western Australia, but the High Court took an entirely different view of that. I think that is an area that could arise again, and it's the commercial side of the question that arises in relation to a bill of attainder, which Justice Stewart spoke about at considerable length. I only want to say one other thing about Justice Stewart's paper, and that's in relation to the very vexed situation now regarding what you can do about people who have committed crimes and whose visas are cancelled, or people who are very serious criminals and dangerous criminals and can't be let out into the community. I think people have forgotten that this isn't a new idea, that people can be detained and be dealt with by law and isolated or deported, even though they've served their sentence or paid their debt to society, as it were. In the public interest, there may be a necessity for them to be further supervised or detained or deported. It's not a new idea, because I remember when I started as a young barrister in Queensland, and I'm sure there would have been similar legislation in other states, judges could declare people habitual criminals. And in addition to the sentence imposed upon them, there would be other restrictions or indeed even extensions of the term of their imprisonment, which were never questioned. And now, in these days of political correctness and expansion of human rights, I think people have overlooked that early historical basis for detention or other restraining legal measures in respect of people who shouldn't remain in the ordinary community. This afternoon, people spoke in very, very glowing terms. Nicholas Hasluck, I should say, is a very good friend of mine, and friends usually speak very well of one another, and I think anything that comes from Nicholas I treasure very much, because Nicholas is a great man of letters himself, novelist, playwright, essayist, memorialist and poet. And I'm very grateful for what he has said about what I wrote outside the law. When I went on the court, not long after I went on the court, there was a most scathing review of The Lawyer and the Libertine, my first novel, by two academics in Sydney. And it really was very depressing. And it was a serious question to me whether I should continue to write when I was a judge. And I thought perhaps I shouldn't do it, and I'd been very much discouraged by this review. And then my attention was drawn by one of my associates, Graham Connolly, to some writings by an American philosopher, Martha Nussbaum. And her thesis, one of her theses, it was, I thought, very persuasive. She said all judges need to read fiction. She said reading fiction humanises people, it expands their minds, it gives them often detached but very perceptive and insightful, profound knowledge about human nature. And she certainly also said that judges, if they can write, should write, and they're entitled to write fiction if they wish to. So I was very much encouraged to do that, and I continued to do it. I thought it was not unreasonable to do it, so long as I didn't let it get in the way of my work, and I hope it didn't. I took a lot out of writing fiction. It was, to me, it was not a hobby, but it was an interest apart from the law. And there are many lawyers, not such a lot of judges, I don't think, but there are many lawyers who've been very good novelists. Galsworthy was a qualified solicitor, I think. Patrick Hastings wrote a number of novels. He wrote a couple of successful plays, one of which was made into a film. And there's a very good American novelist. In fact, he's a relative of Jacqueline Kennedy, Louis Auchinloss. And he was also a Wall Street lawyer. And he, I think, really gave me some inspiration in the sense that as a solicitor particularly, but certainly as a practicing lawyer, you've got a lot of tales to tell. You hear a lot of study, you hear a lot of stories, and you have a lot of information and a lot of material. So I saw that as encouragement to write. As for Dyson, as I say, when I was on the court, it wasn't only in the work choices case, in which Dyson and I had different views, but in other cases I felt very lonely because I was a dissenting judge or writing a separate judgment. But a great deal of that loneliness was mitigated when Dyson came to the court, because Dyson and I became very firm friends, and Dyson to me was not only a great source of knowledge on the law if I wanted to discuss something with him, but he is himself a man of letters, of very, very wide reading, and in fact, even today, I'll say to Dyson, sometimes I want to know something. I want some historical information. I ring Dyson, and he always can give me the answer. I've taken a great deal out of his friendship with me, and I value it immensely. I shouldn't say any more. I mean, the perpendicular pronoun I becomes very, very tedious. I don't want to refight old battles or disturb embers which are now dead, but I would hope that perhaps some of the things I said in judgments may make an appearance in the future. I don't want to speak any more. I'm reminded asking an old-timer, a person who has had the best in the past, to speak again can be very dangerous. I'm reminded of a book I read many years ago by T.H. White called The Once and Future King, and it was a fictionalised, very readable, very good book, fictionalised life of King Arthur. And those of you familiar with the King Arthur story would know that his tutor was Merlin the magician. And Merlin thought it very, very important that King Arthur, the prince as he was then, be exposed to the natural world as well as the human world. So one night he turned him into a fish and he swam in the moat with the other fish. Then another night he turned him into a falcon, and Merlin asked Arthur the morning after he'd been the falcon, he said, "How did you find it? What was it like?" And he said, "Well, it was rather like going into the mess of an old and distinguished regiment." He said it was listening to the senior falcon in the mews where the falcons were, talking about old hunts and how many birds and rabbits and hares the old falcon had caught, was like listening to the colonel in a mess, talking about the old skirmishes he won. Now, ladies and gentlemen, you've heard far too much about my skirmishes. A lot of them I lost. I'm grateful for your attention, and I'm more than grateful for the extremely kind words that those who've spoken about me have said today. And I thank the Society. It's been a wonderful interest to me. I intend to maintain my connection so long as I'm able. Thank you very much.
And as well as the applause, a modest gift from the Society.
Thank you very much.